Good morning, everyone, and how are you? I want to take this opportunity to welcome all of you into today's webinar. Please, as all the attendees here, I also want to request you as you're attending, please share with your friends, share with your colleagues, share with anyone else who is an interested party of course, in as far as education community is concerned, because today it's going to be a very, very interesting day, kind of a webinar. And it's an opportunity for us to look at just the normal operations of schools beyond the normal school management, beyond the normal financial management that we talk about. But however, we want to see how do we ensure business continuity, how do we ensure going concern, how do we ensure that our business still remains relevant even without our presence, in case of any kind of in eventuality. Sometimes people, in regards to succession plan, people always think about in eventualities in line with the mortality. However, there is more to succession plan or succession planning of a business. So I'll first of all introduce myself. My name is Betty Simiu. I'm in charge of social impact here at Ed Partners, and having such kind of webinars or even trainings to our customers is what positions us as a brand, as an education partner, and also as a brand that intends to impact schools and the school community or education community holistically. So today I'm excited because we have a guest speaker. We have someone who is well knowledgeable, who has so much of insight in regards to today's topic. And that is none other than Eva Wanja. Eva Wanja, you're much welcome into our today's webinar. And I'm hoping that as you train us, we'll take notes and we'll get to even utilize the information to improve our businesses or even our schools. So just a brief introduction of Eva Wanja. Eva Wanja is an advocate and a certified secretary and a governance auditor. He's also a practicing company secretary and also accredited certified governance auditor at McKay Advocate. She's also, over and above that, Eva Wanja is also an active member of both Law Society of Kenya and Institute of Certified Secretaries, and she's currently a partner at McKay Advocates, a position that she has held since 2014. And in the course of her practice, Eva has advised many companies, families, and individuals on a succession planning and business continuity. Eva also advises a wide range of customers on legal and governance matters. So we're having a very important and integral person who has a vast knowledge in regards to succession planning. So please brace yourself and just be ready. Take notes as we continue learning on how we can ensure that our business continues in case of any kind of eventualities or any kind of decision that might just propel our school director into another level, and they still want to ensure that the school continues running as normal. So without any further ado, I want to take this opportunity to welcome Eva Wanja. Eva Wanja, karibu sana.
Thank you very much, Betty. That was a very warm introduction. Thank you for having me.
We can't hear you, Eva.
No, I'm not on mute. I don't know what could be happening. Oh my.
Yes, Betty. Can you hear me, Betty?
No, I can't hear you, Doreen.
Doreen, can you hear me? Hello?
Eva, we can't hear you. Eva?
Eva, kindly unmute.
Okay, can you hear me now? Hello?
Hi, Eva. I think we can proceed.
Yes, good morning, Betty. Can you hear me now?
Yes, we can hear you.
Fantastic. So thank you very much for the warm introduction. It's indeed a pleasure to be part of this webinar. I hope it will be interactive as much as possible, and I will also get to learn from you and the people who are attending the meeting. So with your permission, Betty, I'll go just right into it, and I'll try to share my screen. Can I share my screen?
Absolutely, Eva. You can.
All right. Okay. So just give me a minute. I'm trying to get it. Is it, you can see it now?
Yes, we can.
Yes, okay. All right. So the presentation today is about succession planning, and I'll just go right into it. Then we can have, I can take questions after the presentation. So I'll start with looking at what succession planning is. And I'm sure most of the people attending the meeting today have heard something about it, or either through reading, through seminars, through papers, and other forms of media. So basically, succession planning is just the process in which the owner of a school, given that today we are talking about schools, puts in place mechanisms or structures to enable the school continue after the founder exists. We have, I know many of the owners of the schools are the people who started the schools. They have grown the schools right from the beginning, from child number one. Now the school has grown up to 100, 500. Some of the schools have even over 1,000 people. So succession planning just involves that process of looking at what is going to happen after the founder or the person who started the school exits the business. And exit be due to many reasons. It could be as a result of death, it could be as a result of sickness, and it could also be as a result of retirement, or it could also be you want to venture into another kind of business. I'm told running a school is not easy because there is so much that happens around a school. We are told that a school is a social enterprise, whereby yes, you are in business, but you have to constantly interact with the society, and the society is also a part of the school community. I had somebody who owns a school speak and say that if the society decides that you're not going to run that school, you cannot be able to run that school. So we understand that a school is not easy to run. So some people may decide that I want to try something else. And before you even get to that position, you need to think about what is going to happen to the school if that happens. So basically, in those many words, that is what succession planning is. And then there's the reason why, the question, why do succession planning? And the most obvious reason is, of course, continuity of the school. For those of us who are in business, not just schools, or like me who is running a law firm, sometimes even if you want to exit, you want that business to stay beyond you. You don't want to start a big brand, sweat through it, and then after you are gone, that brand goes with you. So continuity is very, very important, alongside, of course, the business aspect of things. You really want that name to grow and the school to continue expanding beyond you. Then, of course, there's the issue of protecting personal wealth. Of course, a private school is also an investment for you. So part of the reason why you would want to think about succession planning is to ensure that the wealth that you hold through the school, because of course there's financial or economic value in the school, is protected even when you are not there, or even when you're not running the school yourself. Of course, there's also the issue of securing your retirement. Assuming you are leaving the school to retire, you really want to ensure that you are able to transition the business, and especially if all your earnings or all your income are coming from the business, you really need to plan and see, okay, now the school will continue to be running, you need to continue to be paying me something as I go on with my retirement, and how can I be able to secure this? And then there's also the issue of course, avoiding family disputes. It so happens that sometimes when somebody, God forbid, passes on, and without giving the proper directions on how their wealth is going to be handled, of course, the school being one of the businesses somebody would be running, or the only business somebody may be running, a dispute arises between the beneficiaries or the family members on how the division of wealth, or how the division of the assets, including the assets of the school, will be handled. So it's very important to do succession planning so that the family is also clear on what is going to happen to the school, so that there are no disputes. And we all know that when disputes arise, the focus of the people who are there now shifts to fighting, as opposed to looking at how they are going to grow the business further. Okay, and how do we do succession planning? Most people look at it as how do we plan? How do we transition from me to the next person, be it the next generation, or to that parties who are going to take over the business? But for me, I choose to look at it from, first of all, how do I prepare what I'm holding, so that when I'm passing it over, I am passing something of value? Because if there is nothing, if the school is at a zero, then what will you be passing to the next person? What will you be continuing? So I choose to look at it as what you can do while you are still there. And then secondly, how can you now put in place structures to transition for your exit? So I look at how to deal with it when you are still there. And one of the things that we have realized is the issue of registration. When you're starting a school and what most people do is that they go for the simplest form of registration, because at that time, maybe somebody does not have enough resources to be able to go for a complex or a more sophisticated kind of registration. And the law has various options, but somebody can start from the lowest option and go graduating and building on as the income grows. So the options that are there, one is a sole proprietorship. A sole proprietorship is basically an individual registering a business name. And once they register the business name, then they start operating through that particular business name. The law provides that a sole proprietorship ends on death of the proprietor. So immediately the proprietor dies like this, that business ceases to exist in law. That is what the law provides. But now the assets and the liabilities of a sole proprietorship pass to the estate of the deceased or the person who has died on death. If people want to continue using that name, then they can only do a change of particulars, and whatever comes up is a different sort of a business. So there is no continuity in a form of a sole proprietorship. And I know there could be people who are operating the schools by way of sole proprietorship. Please note that upon death, the sole proprietorship or the school or the business in the school ceases on death. And the law further provides that there is no property, or there's nothing to pass in form of a name. That is why we do change of particulars and things like those, instead of doing a transfer of that particular business to somebody else. Now, closely similar to a partnership, to a sole proprietorship is a partnership, which is basically a business name that is registered between two. Now, the law also provides that on death of a partner, that person ceases to be a partner of that business. So if you have registered your school as a partnership between two people, if you die, then the business is left with the partnership. If there are only two people, then the partnership ceases and it becomes a sole proprietorship. And what happens is that the assets and liabilities that the partnership had at the time of death, they should be accounted for, and the person and the share of the person who has died is then given to the family or the estate of the person who has passed on. So a partnership is not also a very ideal way of running a business, because it doesn't have a separate entity from the owner. So the other, to be able to deal with those issues of the general partnerships and all that, the law created, we were given just a few years ago, there was a law that was passed called the Limited Liability Partnerships Act, which basically creates a partnership that has a separate legal entity from the usual partnership. So that particular kind of structure has a separate legal entity from its owners. But the catch is this: when a partner dies, then the assets of the partnership should be looked at, and then whatever belongs to that person who has passed on is, of course, given to the estate. So in as much as it has a bit of some tax advantages, in the sense that every partner accounts for their taxation and all that, it is still not a very ideal way of running a school. Now, the most ideal structure to run a school is a company, because as we all know, a company has separate legal entity from its shareholders and directors. And I know most of you are running the schools through company. So you need to look at where you are and see whether the entity that you are using is actually the right entity to run the school at this point, and also to help you in terms of succession planning. So it's also important to ensure that the school, of course, complies with all relevant laws, ensure that it is properly registered under the Basic Education Act, you're complying with all other laws, including employment laws and all that, because you know breach of laws and regulations poses a real risk to a business. If you fire somebody, assuming you breach the employment laws, and you fire somebody improperly, then that person can go to court and they come back with a judgment that praise what you have in the school. So it's very important that you keep on checking and ensuring that how you are running the school complies with all the relevant laws. And also, it's also important in as far as possible to also ensure that you're separating the assets and liabilities of the school from yourself and from other businesses. There are people who have multiple business. You find that where you have erected the school, maybe that property, you have charged it for some other, business. Maybe you're doing supplies, tenders, or you're doing real estate and all that. And when that business fails, then, and assuming you have charged that property to a bank or something like that, then they will come and want to sell that the asset that you are using for purposes of running the school. And if then that happens, then you'll have a problem of where to locate your school to. So those are things that somebody needs to think about, so that to ensure that the school is healthy while you are still there, before you think about how you're going to pass the school to the next generation or to the next person. Okay, now that we have looked at how to just properly run the school, now let's think about now succession planning. And when we are looking at succession planning, I think for most people, of course, it's our desire that the business that we have started and we have struggled so much to be able to grow is passed to the next, to our family members, perhaps our children or our close relatives who are willing to run the school. So, and sometimes that is not possible. I've heard of people who have, they have done so much in Kenya. They educate their kids and the children go to study abroad. And when they go abroad, they really don't want to come back. So what happens when you don't have somebody to run, somebody from your family to sort of run that particular business? So at that point, you may find that you may need to look for third parties to be able to take over the business, especially if you are interested in carrying in the name of the school growing and all that. So, but first of all, let's look at the usual situation, which is to pass the school or the business to the next generation of in your family. That could be children, it could be a spouse and all that. So that can be done in several ways. It can be done through wills, it can be done through family companies, it can be done through family trust. We are going to look at each and every option I've listed in there. So we start with wills, and basically a will is just a legal declaration by a person of what is going to happen to their property upon their death. So a will is done by a person when they are still living, but it only takes effect on the death of the person who has written the will, that is the testator. So in the event that your school is a sole proprietorship, then the will be able to provide for what happens to your assets and liabilities. Remember, we said that legally speaking, when you die as a sole proprietor, then the business ends you, because there's no separation between the business and you. And I'm sure when you have seen in most cases, even when you are borrowing and you are a sole proprietor, assuming I'm the one who is borrowing and my name is Eva, then, like the title or the charge document is going to read as Eva Wanja trading as Eva Schools or something like that. That just goes to tell you that there's no separation of the proprietor and the school for a sole proprietorship. In case of a partnership, the same thing, where you are sharing the partnership, of course, forms part of your estate. And if you had done a will, then the will is able to provide for what happens to all that. Now, whereas the law says that a school or a business stops operating upon death of the owner, because of, sometimes our laws are not in harmony. What we usually do when somebody passes on and you go to court, you do a succession, of course. If you had a will, succession is easier because that is a probate. What the court does is just to go and verify what is in the will, and after some time, of course, give you the grant of probate, which is like a court order allowing the executors to distribute the property as per the provision of the will. Now, in case you did not leave a will, of course, the process is much longer because the court has now to appoint administrators and all that. And, people have to agree on how property is going to be divided. But eventually, after you get the the confirmation of grant, either for where you had left a will or where you had not left a will, it's possible to go to the registrar of companies and, of course, now change the particulars of the business name so that the administrators of the estate can now hold that particular business name. But ideally, the law says that the school business should stop on death. But it's possible for the administrators to continue, using that particular name. But what the law says that the people who start using that particular name going forward, then that is considered as a new business, and they are liable for the debts, and they own the assets that now come into play after that. But whatever was there before death, of course, belongs to the estate of the deceased person and is distributed as per the court order, either as per the will or what the court decides if there was no will. So a will is an ideal situation where you are a sole proprietorship, or where you are a partnership, because it's going to speak onto how the assets are going to be handled. Maybe the school had even a property, or maybe it had other assets. So the will is going to say what happens to those particular assets. So in as much as the sole proprietor is not or a partnership is not an ideal form of running the business of a school, if that is what you have, before you transition, it is advisable to have a will so that the people who are there after you go are clear on what should happen to the assets of the school when you are not there. Okay, then of course, the process of writing a will, you just need to have a list of the assets, a list of the liabilities, a list of the beneficiaries and how who gets what when you pass on. You need the executors. Executors are the people who are going to execute or implement the will. They are the people who are going to do what you have said should be done when you're not there. Then, of course, there is another class of person called the trustees. These are the people who hold the assets before they are distributed to the beneficiaries. Most will say that the executors are also the trustees, and that is the simplest way of doing it. But it's possible to create trusts, especially when you have small children, and have the trustees hold the property or the assets up to when the children become of a certain age. Because assuming your kids are very young, maybe you would want them not to hold their assets legally, maybe until they are 25 or 30 or whatever age. So you can appoint another class of person called trustees who are going to hold those particular assets until the children become of that age that you want, or even the age of 18. Before at which point now the trustees can transfer the assets to those particular children. Then, of course, you need two witnesses who must see you signing, and you must see each other signing the will for the will to be valid. So the process is, of course, after you list all that, assuming you're dealing with a lawyer, after you give the lawyer all that, they are going to draft the will. And once you confirm that the will has what you want to happen, then, of course, the next step is the process of signing and witnessing of the will. It is very important that you consult a lawyer when you are doing that, because the Law of Succession Act is very clear on how wills should be handled. And I'm sure you may have heard of many cases where wills have been invalidated. So it's very important that you consult a lawyer to ensure that everything is adhered to, so that your will is not declared invalid when you're not there. Then, of course, the next thing is also you need to think about how that will is going to be stored. If you don't store your will very well and people come across it and they discover you never left something for them, they will not be very happy with you during your lifetime. So it's very important to think about how the will should be stored, of course, away from your beneficiaries and all that. And people should know what is there when you are gone. So you can consider keeping it in a safe deposit box in a bank. You can consider keeping it with a lawyer or somebody else that you can trust. Some people even keep them with accountants and all that. Yeah. So it depends on person per person. Okay, then the other instruments that you can think about for purposes of succession planning, where you want to pass the school to the family, you can think about family companies. Of course, we know what companies are created under the Companies Act. That is a company limited by shares. Of course, there are other companies which are not ideal for the purposes of running the business, a business, and in this case, the business of a school. So we know that the owners of a company are shareholders, but shareholders also appoint directors who the law puts the business of the responsibility of running the business of the company in. And the shareholders and the directors can be the same. So the advantages of the family company structure, and this basically are advantages of having a company, is number one, companies have legal separate have a legal personality which is separate from the shareholders and the owners, and they also have perpetual succession. So in case there are any risks, maybe against you, assuming you had given a personal guarantee for something else that does not involve the school, if things happen and somebody wants to enforce, then they cannot enforce against the school. They can only maybe go for their shares, but they cannot go for the business as it is. Then in case of death, of course, the company continues operating because it is separate from the owner. So that is a very big advantage as compared to sole proprietorships and partnerships. Then, of course, the family gives now the members of the family a stake. You can give the members of the family a stake in the business through owning shares. Assuming you have maybe 1,000 shares, so you can give your wife or your husband a share in the business, could be as you wish, or your children as they grow. You can go now maybe increasing the shares and all that as you try to exit the business. So of course, I've spoken about liability is limited, and then it's worth noting that there is the Stamp Duty Act. The Stamp Duty Act allows a family member to transfer a property to a family company without paying stamp duty. Assuming the school is in your the premises where the school is in your name, and now you want to transfer it into a family company. And by this I mean a company where you own with your spouse and maybe your children or your spouse only, as long as you are able to prove to the collector of stamp duty that it is actually a family company. And in this case, they will ask for things like marriage certificates and things like birth certificates. Then they are able to exempt that particular transfer from the payment of stamp duty. I think that exemption was put in place to be able to ensure that families' assets can be transferred and be held through family companies. Okay, then of course, the disadvantage of using the family company structure is of course that now at the moment you start giving your family shares, then the ownership of the school is split among the shareholders, because everybody owns a share of the school or the business proportionate to the number of shares that they hold. So now the school is owned by many people through different separate units. Then the other thing is that subject to preemption rights, and most private companies have preemption rights, a shareholder can sell shares in the company to an outsider. So although there are safeguards that we try to put in the memorandum and articles of association, if that is not taken care of properly and people do not get the right advice, you may find that your child who has decided, mzee anakanyagia pesa sana, all the money that the business is making is being put back in the company, somebody can decide to sell their shares and cash in. And you end up now having somebody that you don't intend to have in the business. And the other thing is transmission. Ideally, in most cases, and through the general articles of association, the preemption rights or the restriction towards transfer of shares does not apply in case of transmission. That is in case of death or in case of bankruptcy. So a good example is maybe you have given shares to your child, maybe your son or your daughter, and then your son or your daughter is married, and when they pass on, remember now their nuclear family is their immediate family. So it is possible that you may find the spouse now of your child becoming a shareholder in the company through transmission, and maybe it is somebody you cannot be able to work with, God forbid. So that can pose, the family structure can pose that particular the family company structure can pose those particular challenges. So of course, the process of registering a company is basically collecting the things that you need to file to apply for registration. That is the details of the shareholders, the details of directors, the name, where you are going to have the registered office, most ideally where you are conducting the business of the school, and all those other requirements that the registrar of companies have. Now the process of registration of a company is easy. You can do it for yourself through the eCitizen platform, or you can get a lawyer to do it for you. Now it's possible to, the Companies Act of 2015 gave us some template or some model articles of association. So you remember a long time ago, we used to have booklets for memorandum and articles of association. The government, in a bid to ease the cost of doing business, streamlined that particular process and gave us model articles of association. But you may want to run your company slightly differently. You may want to put safeguards, some of them like the issues of controlling how people can sell shares. You may want to control decision making. You may want to say that as long as I'm here, having worked this much, and then I would want to veto the position of the directors on any of these issues. Maybe issues of borrowing, maybe issues of purchase or sale of property, maybe the issue of opening branches. So all those things we can be able to, as lawyers, we are able to put them in what we call the shareholders agreement or the amended articles of association. Then once the company is set up, once the company is set up, then you can now transfer the assets of that are being held by the founder to the company. In that process, we have said, first of all, it's stamp duty exempt. Maybe the only thing you need to do is to get consent and now be able to transfer the property. Maybe you will have to pay the other cost of maybe transferring the motor vehicles, maybe I don't know all that. An accountant can be able to help and see how the assets are able to move from the founder and how they sit in the company. But as regards property, which is what is most substantial, the process is pretty straightforward. Okay, now the other kind of structure that you can use to be able to pass the school or the business to your family is, of course, the family trusts. This has become a very debated topic of late. A few Fridays ago, I think like 2 weeks ago, there was a story about Manu Chandaria in the Business Daily, and he was saying that he doesn't own anything, neither does his family members own anything, and that what he does is that he earns an income from the trust. The family trust. So it's an instrument that most wealthy people are using for purposes of holding a family property. So if you look at, so what is a family trust? There is an act that was enacted in 2021 called the Trustees and Perpetual Succession Amendment Act. And it has tried to improve the law that was there on trust, especially as concerns family trust. That particular provision in Section 4 provides that a family trust is a trust, whether living or testamentary, partly charitable or non-charitable, that is registered or incorporated by any person or persons, whether jointly or as an individual, for the purposes of planning or managing their personal estate. So basically, it is a trust that is incorporated for purposes of planning and managing their personal estate. So basically, this is an instrument that that has been put in place for purposes of succession planning. Yeah? So, having said what a trust is, what are the parties to a trust? Of course, there's the settlor. The settlor is the person who now gives assets to the trust. And they are the trustees, the people who hold the property in the trust and who make decisions as regards the property in the trust. And they are the beneficiaries, the people who are supposed to benefit from the trust. The law provides that the settlor, the person who gives the assets to the trust, can also be a beneficiary in the trust. And they can also be a trustee in the trust, of course, for as long as they are alive. Then the law has provided for a very other interesting category of persons called an enforcer. This one is like a cop who checks what the trustees are doing. And I think this has been informed by the many stories that we have had in the media about how, trusts have failed some beneficiaries. And I know you have read about that. Okay, so what are the advantages of a family trust? One, separates the ownership of the school from the founder. Now the school or the business is going to be owned, of course, by the trust. But then, of course, the trust ensures that the business is not split into small pieces, so that it is owned by the trust, and the trust can own the school. So you can have the school registered in the name of a company, then the trust owns the shares in the company, so that the shareholder is the trust. So if then that is the case, then the ownership of the school is not split into several pieces. The children are not each holding a few shares in the company that holds the school. And because that trust is there, then the ownership of the school does not keep on changing. The trust is there perpetually. So it will remain as the shareholders. Beneficiaries will come, they will go first generation, second generation, and all that, for as long as the trust is not revoked. Then there are tax benefits, of course, of using the family trust. And one is that you, as a founder, when you are transferring the assets to the trust, then you don't pay stamp duty, and neither does the government come for you for purposes of capital gains tax. The law also provides that the money paid from the trust for purposes of maybe medical expenses, health, and well-being of the beneficiaries in the trust is tax-free. Also, the law also provides that the distribution for a beneficiary of a trust up to an amount of 10 million in the year of distribution is also tax-free. So, of course, there are quite a number of tax benefits that family trust present. So, of course, what has been the challenge, and what that law that was there in 2021 has tried to cure, has been now the process of registration. Because initially, the registration of a trust is actually twofold. One, you prepare the trust deed, and once the trust deed is prepared, then you register it under the registry of documents, and then once you complete that particular registration, then you apply for incorporation of the trustees, for the trustees to be a body corporate. So the process of incorporating the trustees was initially a bit lengthy because the certificates were being signed by the minister. But now this law of 2021, which I think has not been fully operationalized, has provided that now the registrar under the Registry of Documents Act can now be able to sign those particular certificates. And it actually provides that within 60 days of the application for incorporation of the trustees as a body corporate, he's supposed to issue the certificate of incorporation. So if it is only 30 days or maybe around 90 days, I think that period is not too long, especially now seeing the benefits that are there. So it's something that is that I think the benefits outweighs any sort of disadvantages that we can think about. So, of course, I've talked about the process, which is prepare the requirements, have the trust deed done, and ensure the trust deed is done very well, and you have discussed it, and you have looked at it, and you have reviewed, and you have amended, and you have asked all the questions, because this is the document that is going to govern how the trust is going to be handled. Then once the trust deed is done and it is executed, of course, it is registered under the Registry of Documents. Then you go to the incorporation of the trustees. Once the certificate is issued, then now you can start transferring the assets to the trust. Now, the law provides that the family trust is not a trading entity. So it cannot own the school directly because the school is a trading entity. So the best thing is have the school being run in form of a company, that is EVA Limited, EVA School Limited. And then EVA School Limited is now owned by the family trust. And the other reason why you want it to be done that way is so that you do not also expose the trust to liabilities or litigation. Let the school or the trading entity, whether it is the school and any other business that you may be holding, that you want to put in the family trust, be held by other trading entities. But now the underlying ownership, let it now be family trust. So we said that some founders find themselves in a position whereby the children or the family is not willing or is not even able to take up the business and to move it forward. So at that point, you may want to consider now maybe passing the business to third parties. It could be employees or it could be investors. So how do you do that? For employees, you can consider an outright sale where you sell shares to employees, or you can consider that since while you are still there, you commence an employee share ownership scheme or plan, which we commonly call ESOPs, or you can consider now the issues of selling shares either in whole or in part, which is done through mergers and acquisitions. So basically, an ESOP is a scheme for encouraging or facilitating the holding of shares in a company for the benefit of employees of a company. And basically it provides that you may want to share the profits that you are making in the school with the employees, so that assuming you make this and this profit, then a percentage of it goes to an ESOP, or you may have even performance-based mechanisms that enable employees to acquire shares in the company, of course, through the ESOP. So basically, the shares that are being held by employees are put in the ESOP, and then employees now own units in the ESOP. And the ESOP is basically like a trust that owns the shares for the employees. And depending on how you have done your the trust deed and the rules, it may provide that once somebody stops being an employee of the school, then they should be able to return the shares that they had, and then they are given money in consideration of those particular shares. But you can also decide to have ex-employees as a member of the ESOP. It all depends on how you do your drafting. So advantages of ESOP is, of course, to encourage employees to continue to stay on and continue running the business of the school. It also encourages higher productivity as employees have a share in the profit of the company. And also tax efficiencies. There are some money that there are tax exemptions for particular monies that the company pays to the ESOP, or the amounts that the company transfers to the ESOP, be it profits or whatever kind of financial assistance that is given to the ESOP for purposes of purchasing the shares of the company. Okay, so the process, of course, is first of all to look at your governance documents and see whether it allows for a setup for setting up of ESOPs. The second thing is, of course, now setting up the ESOP. Basically, it's a trust, so the process is closely similar to what we have discussed in trust. Prepare the trust deeds and all that. Then after that, of course, there is now the process of now the acquisition of shares and transfer of shares to the ESOP, and now and this is ongoing. As well as the issue of allocation of the units in the ESOP to the employees. Okay. So I'm sure you have had, going on to mergers and acquisitions, I'm sure you have heard of the many stories in the papers of owners of schools who have sold, like McKinney, yes, there are quite a number of companies that have been able to sell shares in the schools and exit completely. So this process, you can sell a part of the shares, or you can sell all the shares. You can sell a part and tell these people who are coming in to carry on with the management of the school, and you as a shareholder, you just earn dividends for the shares that you are holding, or the shares that your family will be holding when you are long gone. Or you can even decide to do a share swap whereby there is a sister school or a neighboring school or another school. You tell them, I want to exit from the management of this particular school, but I don't want to exit as an owner. Can we swap shares in this company so that you run that school? Maybe that other school has more operational efficiencies than your school, Maybe they have better technology that in your school, they come and continue running your school, and then you get shares from the other company. So there are many ways of structuring this. It just depends on circumstances. So the process is, of course, negotiations. Once you negotiate, you agree on the main terms. We put that in a document called a term sheet or at the heads of terms. Of course, there's the due diligence, getting to know each other, looking at have these people been paying taxes, what are the liabilities, and all that. And then after that, of course, we do the transaction documents, which are the share purchase agreements, where you're buying shares, share subscription agreements, where you're issuing new shares. And once the agreements are done, most likely you'll be paying a deposit at that particular time, and then there's a period for completion, within which period we are able to look for to get all consents that are necessary for purposes of selling the school, including the competition authority consents and all that. So then after the completion period, of course, there is now the exchange of the ownership and the money and the issues to do with board restructuring and all that. So it's basically a process that depends. This is the general way of doing it, but what happens depends on the nature of the transaction. Okay. So we are done with ESOPs, and we are done with mergers and acquisitions, and I think that is all I have for you, ladies and gentlemen. And I'll just end by a quote by Benjamin Franklin that says, if you fail to plan, you are planning to fail. So thank you very much, Betty, and back over to you.
Thank you so much, Eva. That was quite insightful, and thank you for impacting such kind of knowledge to us and also the school directors or to the school owners and our portfolio. This is actually a very key knowledge that any kind of school owner, school director needs to have to ensure that their business has some level of going concern. So normally, in normal sense, most people fear succession planning. When they talk about succession planning, you only think about death. But when you talk about succession planning, it's more than even death, of course, God forbid. It's more than even death, but it's just having clear strategies and plans to ensure that as you continue running your business, then in case of anything that might occur, or in case of any occurrence, or in case of any shift in line to maybe your business, just to ensure that that your business is continuing, then you have strategies in place to support that. Thank you so much, Eva. And before we end our webinar, I would also give a chance to our attendees or even school owners to ask questions. If any of us has a question, you can always just raise your hand so that we can give a chance for you to get any clarification. So we are welcoming any kind of questions, any kind of clarification that you might need as at now. Karibuni sana. I'm seeing a hand from Brian. Yes, Brian, you can ask your question.
Hello.
Yes, Brian.
Are you able to hear me from your side?
Absolutely.
Okay, fine. I don't have really a question as at now, but I am requesting for if you can bring this training for the financial parts on the financial management part.
Absolutely, yes. We can always have arrangements around that. The same will
Yes.
be communicated to you via
Yes.
various channels on how we'll avail that in terms of webinar or even just a physical training.
Yes, thank you.
You're welcome. Any other question from any of our attendees today? So it seems none. So I'll ask maybe Eva just one question. In case of maybe any kind of maybe advisory, are you open probably to share kind of legal advisory in line, of course, with succession plan to some of our school owners? Are you open maybe to just have a discussion in case they want any inquiries? Maybe is it okay if we can directly contact you?
Okay, thanks, Betty. Yes, we are open. I will share our numbers with you, and we'll be open to answer any questions that somebody may have on the same.
Okay, so then I've just seen a question. Mercy is asking, kindly can you do a repeat of the same? I've missed a lot. Oh yes, Mercy, yes. Mercy is requesting whether we can have a repeat of the same kind of a training or webinar. Oh, absolutely, Mercy, yes, we can. I will arrange for the same, probably for a repeat of the same with, of course, Eva and a Mackay advocate. So we'll always do that, absolutely. And then I'm also seeing a question. Zachary Ngare is asking whether, Madam Eva, you can share the presentation.
Sure, Betty, I'll send it to you.
Yes. Okay. And also the same has been recorded, so we'll also post it on our YouTube channels, even in our LinkedIn and some of our various social media. So you can always go back and do and re-listen to or just have a recap of the same. Over and above, the same will also be shared to some of our attendees via email and also through our relationship managers. I'm seeing another question. Andrew Langat is asking, how can you register trust deed of a school hosted by a church? That's quite interesting, Eva.
Yes. Okay. It's interesting because around, I think in the course of last month, I had the same discussion with a church, and for a church, you know, it's a bit different as compared to a family. So you can consider either having the trust, the usual trust, and of course the Trustees Act and the Trustees Perpetual Succession Act, or you can consider having a company limited by guarantee, because ideally a church is a charitable organization. In as much as a charitable organization is allowed by the law to conduct conduct or to trade for purposes of making money that is going to be used for purposes of the charitable organization. So basically, I would say because a school is a trading organization, you can have the company, the private company limited by shares, but under it is owned by the church, either through a trust or through a company limited by guarantee.
Oh, thank you so much. Yeah, that's quite interesting.
Yes, and he can also reach out to me. I just share more insights that are focused towards that.
Okay. Andrew Langat, yes, we'll share Eva Wanja's contacts, of course, under Mackay Advocate for any kind of advisory. But however, it's still possible to have such kind of a registration under limited by guarantee, Eva, if I'm not wrong.
Limited by guarantee or also as a trust. But the rider is, it always depends on how the school and the ownership is structured. So while it is possible, it is important that we listen to your story, understand the structure, and see properly how many layers do we also need to have. Because again, if you have so many layers, the tax and the operational inefficiencies increase, and you end up spending much more. And you see, like the companies, you have to keep on filing returns every other year, both company returns and income tax returns.
Okay, so hope Andrew Langat, your question has been answered, but for more information, we'll just link you up with Eva Wanja so that you can have a discussion and advisory around the same. Eva, Collins Ligami is asking, can a will be amended by the beneficiaries?
The answer is no. It can only be amended by the testator or the person doing the will before their death. And the Law of Succession Act provides that how that should be done. It should
Yes.
the amendment should be witnessed again by 2 witnesses, and the earlier provisions of the will should be revoked. That is the answer is only a testator can amend a will. The beneficiaries cannot amend a will, but the Law of Succession Act, section I think 26, allows the dependents, people who are being taken care of by the deceased, if they feel that sufficient provision has not been made for them, they can go to court and ask the court for sufficient provision. And if the court deems that sufficient provision was not made for them, it can make an order altering the distribution that was there in the will.
Absolutely. Okay. So Collins, hope your question has been answered. It's a no, it cannot be amended unless the person who wrote the will is the only person who has the right to amend a will. However, for more information, of course, we still have Eva Wanja with us. He can always offer advisory in regards to the same. I'm still open to receiving questions or any clarification or any requests in regards to the same. Yes, we have 2 participants who are someone. We have David Mutai. David Mutai has a question.
Hi, say thank you first and foremost for the presentation. This was very timely, and I think this kind of messaging needs to go to all private schools in the country. And I was wondering if you could also develop a newsletter that could schools, because the leadership of schools across the country is aging, and most of them don't have a succession plan, or they don't trust them to run the schools. So this kind of thing needs to get to them. I'm sure most of them may never attended the meeting today, but maybe a newsletter to them, but a continuous process for us to schools would be very useful. Thank you very much, Kay.
Thank you so much, David. I'll respond to that. Yes, we can write an article around it. Actually, we have just launched our Impact newsletter as Ed Partners, where we'll be communicating such kind of insights and even sharing information on what is happening in the education sector. And this, of course, will inform our next article for our newsletter, and we'll share with you via emails. And also, I want to also let you know that the same has been recorded, and it will be shared in our major social media platform, including YouTube. So we'll also share the link with you. And please, once we share this information with you, please also share with other directors, because we are part of the education community, and such kind of insights, we don't need to keep it within ourselves. It's for the whole education community to have to benefit from it. So yes, David, thank you so much for that kind of suggestion. We'll put it in article, and we'll also share the recording of this webinar.